A very good morning to one and all. I, Ritupriya Gutu, welcome all the distinguished guests, students, faculty members, and all the participants to the 16th International Conference of Prestige Institute of Management and Research, Indore, on the topic Innovative and Adaptive Management Strategies for the Sustainable Entrepreneurial Business and Societal Growth. We are very fortunate to have with us for the Law Conclave today, three eminent guests. The two guests that we have are from the academic field, and the one guest that we have is from the judiciary itself. So the guest that we have for today's event is Dr. Vikas Gandhi, Associate Professor, Gandhi Nagar National Law University, Dr. Tapan Mohanty, Professor, National Law Institute University, Bhopal, and Dr. Ss Yadav Ji. He is a retired additional district judge of Indore. A brief introduction of all the guests to our participant. The first guest that we have is of Dr. Tapan Mohanty. Dr. Tapan Mohanty is basically a professor of National Law Institute University, Bhopal. And during the last few years, he has worked extensively in the area of globalization, tribal development, and culture of consumption. And he's basically a sociology of law. He's basically very much interested in numerous research projects, and he has also worked with organizations like World Bank, Ministry of Environment, Forest, and National Commission for Women. We also have with us, next slide, sir, please. We also have with us Dr. Vikas Gandhi. And Dr. Vikas Gandhi, he's basically an associate professor of Gujarat National Law University, Gandhinagar. And he is basically having an experience of 13 years in academics and research. And he also has a very keen interest in alternative dispute resolution, human rights, international humanitarian law, and refugee law. We are also honored to have with us Shri Ss Yadav Ji. He is basically an additional district judge of Madhya Pradesh. He has retired from his post, but he had served in the judiciary from last 25 years. And we are really honored to have you here for this conclave of ours. So the format for today, that is, we are having a law conclave, is that I will open the floor to all the dignitaries for around 10-15 minutes, wherein there will be an open discussion on the topic, judicial reforms in India, key to sustainable and inclusive growth. And after all the dignitaries have spoken, it would be an open discussion with the faculty members and participants. So let me start with you, Dr. Vikas, sir. When we talk about judicial reform, we basically talk about two aspects. One aspect is that we need law that that has to keep changing with the time, so as to keep pace with the society. And second is the fact that we need cases to be disposed of at a speedy rate, thereby ensuring that a fair trial is also being given to the people. In light of these aspects, how would you rate the progress of judicial reforms in India? Sir, you have to unmute yourself.
Thank you, Professor. There are two things in my mind. Recently, I completed one project, and which is very related to this project. And recently, it means 3 months back only, I submitted the research to the Government of India, Ministry of Law and Justice. And the topic on which almost 2.5 years that empirical survey conducted in the state of Gujarat, that was related to how to improve the efficiency of the district courts in the state of Gujarat. And it is very relevant question. I'm really fortunate enough that I'm able to justify both the questions that you have asked. The first is that at the time of empirical survey, your first question is related to the amendment and the changes in the law, which may expedite the judicial process or a judicial procedure. What I felt it is that at present this is the major task that is undertaken by the Law Commission so far as the amendment and the existing laws which are required to be changed. This is number one, and a fantastic job as an academician, as a researcher, that I can say that the Law Commission of India does at present. Apart from that, there is a responsibility of the academician, which I feel that through a research that has come up with the policy changing recommendations. Now, in that, there are certain aspects which we have to be taken care of as an academician or as a researcher also. When we are preparing the questionnaires to ask to the honorable judges, to the senior lawyers, basically, and the public prosecutors, right? Three major acts, that is the amendment in which it is required even today, is that the Criminal Procedure Code, Indian Penal Code, and the evidence. And that is based on obviously some responses that we received to ask the questions to the different stakeholders during the research. This is number one. So if we make some changes, because in real field, the stakeholders gives a proper response, and what they feel, we have to be read out with the substantive laws and the procedural laws which are exist. And this is our job as an academician, that how we can recommend, which would very practical in nature. Sometimes it happens, and I also heard it as well, saying that the suggestions are not been practical enough, where it's more related to the jurisprudential aspects, and it's very difficult, in fact, to implement on the ground root level. So that also been taken care of. So the amendment, how it requires exactly the words that which need to be changed in the existing provisions, right? As I said, in the CRPC, in the IPC, and in the evidence law. For example, I give an example. Nowadays, we are looking for artificial intelligence, right? At the same time, we say that a wonderful initiative that the Supreme Court has taken, that is the e-filing system, right? It has been started. Wonderful initiation that e-courts now has been established a very proper way. Even if you look at this stage itself, if you look into the Supreme Court official website, you may find the number of cases which are pending, even not pending per se, but at which stage it is. So it's a wonderful initiative, I personally believe, because that has helped me a lot at the time when I started research in the beginning. Now the issue is that that's what the amendment requires. In that, how far we able to sustain this artificial intelligence utilization. That is very, very important. And to what extent it should not be a part of decision-making process that Honorable Justice has already been said, but obviously it's an administration process. We are really forward to see the administration process using the artificial intelligence. So this is number one, the first question which was related that amendment is required or not. So it is our responsibility as an academician, as a LLM student, as a PhD student also, right, that how we are looking into, and our contribution in the policy level making in that way is very essential. Unless we be a proactive as an academician, as a researcher, I think then it would be unjust from our part, right, that we cannot contribute to the policy level. This is number one. Number two, that pendency of the cases, that the question you have asked on. It's I think, unfortunately, I would say, or fortunately, I do not know, but it's still a contemporary point, because it's a very old, patient question, but still it's contemporary. And obviously, yesterday only, I think, Honorable Chief Justice of India has made certain comments also, right, that infrastructure development is also required, or at the same time, but it's fine. My personal thought is that at present in this situation, how do we reduce the pendency of the case? And for that, law commission report also can be read out, which divided, on 4 aspects, right? Pendency can be reduced on many ways by improving it. And this is number 1 is that infrastructure development is required. Obviously, then at the same time, you can say the decision-making process by bifurcating the stages of the cases is very essential. Introduction of alternative dispute resolution, and now we all are aware that mediation is going to be a mandatory provision before the the case go for the trial. Mandatory mediation process, the law now has been initiated of. So I think on that we have to be more focused on. So in existing structure, infrastructure at present, or you can say that in existing overall academic structure also in the court, how we can improve, we have to be more focused as a researcher, rather than to simply criticizing all the time that this is not working, this is not working. It's fine. It has to be worked upon. There's no doubt about it. Unless it has been improved, it would be very difficult for us to, cope up and match up with the backlog. But at the same time, I would say that my role as an academician has to be provide more authenticated, very based, rooted research, and then provide to the policy making, either to the judiciary or to the government. That's what I feel. Right. So at present, we are going on a very right pace. Slowly, we can obviously cop up, the backlog as well. Right. So this is what my observation based on the research which I recently finished up.
Thank you, sir. You have actually given me many questions, which I'm going to discuss with you in later on stage. Let me come to you, Mohanty, sir. As a law student, we have all studied that society cannot do without law, and law is that bond which actually ties, has a very major plays a very vital role in the society. According to you, how important do you think that judicial reforms need to take place in a cohesive manner so that the economic progress of the society is not hampered?
Yeah, thank you, Ritu. This is a very valid and pertinent question, linking society and law along with the lines of justice. And I must congratulate that your institution, the Prestige Institute, is organizing this conference with 2 very important concepts: sustainability. We're going to talk about sustainability and inclusiveness. And I believe both these concepts are sociological in nature and inherently and intrinsically linked to the 3rd concept, which is called entrepreneurship. Now, if you do not include entrepreneurship, inclusivity, and sustainability, then where do you end up? You would end up with exclusion. You will end up with a division. You will end up with lack of growth and underdevelopment. So law isn't often, as I say, both in outside sociology and within the sociology class, that it's an instrument of social transformation. And how it is, because take an example like environment and justice. If you do not give justice to people, can we ensure environment? Because if people are not getting food, people are not getting fodder for their animals, people are not getting, basic fuel. So if fodder, fuel, other forest resources are not available to them, they will invariably cut the forest, cut the trees, kill the wild animals. Only when you decrease their dependency on them providing an alternative, then ostensibly they will look it. So that means they must have a share of the resources of the country, which will provide an alternative path if we intend to save our environment. So environment and justice in that way linked. Similarly, what we expect from law? Primarily, we understand law is a mechanism of conflict resolution. Now, if we will, where are the conflict crises? Today, there is a conflict between man versus wild. We said Every time you will find a leopard is here, a tiger is killed. Why it has happened? If you go to Uttar Pradesh, you find how Nilgais have devastated acres of land. So there has been conflict in that level. Now, if that has happened, how do you use the law as a mechanism to deal with that? We look at laws like, I was talking other day, the protection of civil rights. Look at the protection of rights of the scheduled castes and scheduled tribes. Now, when you look at them, why it is there? Because you are keeping a number of people alien from the orbit of your development process, who have not very limited share in your growth story. And you find in society, if you look at this in the post-pandemic area, the rich have become richer and the poorer have become poorer. That is a potential degree of conflict. And therefore, the interventions of the courts, either as ensuring development for all and minimizing conflict, is the essential role of law. It is also the rule of law as well. Because if you follow the rule of law, the rule of law will ensure that justice, equality, freedom, liberty are shared, given, and understood really. So that is what as a sociologist I find. But what the problem is there? There are, as Abhishek Manu Singh says sometimes, I would quote that. He said there are 4 problems of judiciary or legal system today. He calls, and I quote, it's called ABCD. The problem of access to courts. A. Many of the times we have lack of access to justice because you have lack of access to court. Right? Who goes to the court? A poor, a tribal, a marginal, and a woman, a physically challenged person have no access to the court. And because they have no access to the courts, they suffer a lot at the hands of people who are excluding them, who are marginalizing them, and who are exploiting them. So that's one issue. Second, you find that is what Mark Galanter calls that a lot of people who have access to the judicial system, they know it, and they are benefited by it, and they actually stall the process of justice by using the mechanisms of court. There are a case for 50 years, a civil case is trying. So that is a question of problem of access. Secondly, the problem of you look at B, it's a backlog. There's a huge 33. There are 3 crore 33 lakh odd cases in the courts. Now there are only 91 lakh cases are pending before the high courts, and there are around 4 lakh cases are pending Supreme Court. Now, how do you look at the backlog of it? And that is why happens Tariq ke baad Tariq. That's what actually happens, because there are so many backlogs, and you continue to do add backlogs. So that is second. Third issue is that what is called about the cost. Now, sometimes do justice have to pay a cost? Do we have to pay hugely to get cost? And it is exactly happening. Many years ago, it was the former president of India, K.R. Narayan, said, the courts are not court of justice. They are courts of evidence. And courts are like, I quote him. He says, and I quote him, the courts are like casinos. If you know the game, if you have the money, you will win. And that is what is happening today. The big companies, the richer people, the corporates, they are dragging you to the court. Why? Because they know they know the procedure, they have a legal team, they have the money. So even if they take your land, you will wait till to get justice. And I like, that's Stals's story. Justice, God see the truth, but waits. But in the wait is probably what a person's lifetime is gone. So that's the problem of the cost. And that is what actually, in a sense, Mark Galanter said, there are 2 sets of people. There are people who goes once to the court for a small issue like maybe matrimonial dispute, maybe property dispute, maybe custodial case, and then they leave it. Then there are repeat players who use the mechanisms of the court so that they can hinder your chances of getting justice. So if I have a small electric line, I am not getting. If I go to the court, against the MP Jal Board or MP Electricity Board. So, okay, the case will lying on there. I will, till then, if I don't grease their palms, my house will remain in darkness even in a Diwali. So that's the problem. Because that is what is happening with the question of cost. And third D is delay. Of course, every law student learns justice delayed is justice denied. But delay is an essential feature of Indian judicial system. That is why I said there are cases where 50 years of cases finding. Supreme Court decided, okay, the father or the grandfather has died, the father has died, grandson gets justice, okay, the case has been dismissed. This is how the delay has taken place. Now, that is why if justice is denied through delay, then what happened? I would quote one case and why our judicial system have been blind to this. There was a case in 1973. A DTC bus conductor, he charged one lady passenger, whatever reason may be, for 10 paisa, which actually to be 15 paisa. When I was a student in Delhi University, the Jawaharlal University, the price was 1 rupee, highest price for the DTC bus ticket is 1.50. And we have a pass for 4 months, for all months, only paying 12.50. That is the price. Anyway, so that conductor, instead of charging 1.15 paisa, charged 10 paisa. And then inquiry was set up. And in 1976, the DTC, Delhi Transport Corporation, dismissed the employee, embezzlement of funds, right? And no, and the court into the court. And in 1984, they say 86, the court decided, district court, okay, it is fine. There is no case in merit. She should be repaid and reinstated. That then Delhi Transport Corporation didn't stop at there. They went to High Court. High Court also took 14 years. 16 years it was taken in the judicial trial court, district court. 14 was taken by the High Court. And High Court dismissed the petition saying that no, he should be reinstated with all backlog edges. This was not deterred. They filed a revision. And after another 10 years, because they neither reinstated him, because by the time he was retired long back ago, 1973 and 2001. So what will happen? The person has retired. So they didn't do it. And finally, the single bench, when they talk about the revision, then High Court said, okay, that is wrong. So that person should pay a penalty of 15 rupees. Because that time, including all the interest and all the things, he should pay 15 rupees 30 paisa to the DTC. And then he should get all his backs. Now, in this case, what happened? What is the meaning of paying a fine of 15 rupees? And when you are reinstating backlog edges, it is a victory. But in a victory for the victim, he also actually become victimized. So in the end of the victory, what happened? What were the family is doing? What type of trauma is undergoing? So this is what is the delay. And that is what determines judicial system. Nobody wants to castigate Indian judiciary because I am also part of it as a smaller, minor part of it being part of the legal system. But the point is that they say justice, and I'm quoting the famous jurist, Nani Palkiwala, and he sums it up very beautifully. He says, justice is blind. We all know. Justice may be blind, but in Indian case, justice is also lame too, because it moves so slowly for that. And law, they say in English, it's a Dickens concept. Look, they say law is an ass. He said, yes, law may be an ass, but in India, it is also a snail, because it moves so slowly and so slowly. So if you look at the ABCD, the problem that is, and I wouldn't take many of the issues how to deal with it, because one issue is identifying a problem. Like I tell my research methodology students, the first problem is to identify a problem. Once you identify a problem, then you think, what is a hypothetical solution to that? Then you test the hypothetical solution in the real field, empirically examine whether your solutions really work out or not. So we have identified the problem. What would be the proper solution? Somebody says ADR, alternative dispute resolution. Somebody said, look at the tribunalization. There was a point where there was a tribunalization of justice. We look at even what is called this Insurance Development Regulatory Authority, Electricity Development Regulatory Authority. Again, the cases go back to the High Court. And many cases, there are single member Consumer Protection Act. Look, in the end of the day, if the court will be cloud with them, we expected in the era of regulation, the regulators will be in a position where they will do justice in terms of their specialized branch of knowledge, like copyright board. But what is happening in the same case, copyright board's case goes to the Supreme Court, right? So ultimately, what happened? Have you been able to do justice to them? Either it is a tribunalization of things, or it is sometimes the government creates structures like CBI and other things, and they, like income tax. We thought income tax regulatory appellate tribunal will do everything, but what happens? In their jealousness, they overuse their power. Sometimes they abuse the power, resulting in these things. So there are delays there is problems in everywhere. So once you do, and I think in ADR, what is happening again? If you go to Singapore Arbitration Council, the case come back again. Look at Balco case, look at Bhatia International case. Both cases, if you take and examine, ultimately Supreme Court, okay, we are original jurisdiction, we are appellate jurisdiction in the country. So you have to come back to here. Now, this is actually what is happening. Even we are trying to find out the solution, but the solution also become more and more problematic. Of course, now we are using, people say blockchain technology, AI. Well, I think artificial intelligence is also artificial. If now my internet goes, light goes, all of us will be blind. So that is how it's also a problem. And if you say, give internet. So what is happening? If you give internet to young judges somewhere, their children will play with the computer and a video game. And ultimately justice doesn't happen. And if there is a computer, there is no internet. If there is internet, there is no electricity. If there is electricity, the computer operator doesn't come. And so this is actually reality is happening. But until as an academician, we have a very little role to play. But I think with the one point I can do, if we can identify a problems, first thing, because identifying a problem is a problematic. If we're able to identify a problem, then half of the problem is over. Once you begin, half over. So I think as an issue, identify. And I'm also happy with the national law schools or similar schools where students are coming. They are more computer savvy. They are more understandable. And some of them are passionate. And some of them are, of course, joining bar and bench. So that is what we are making a qualitative transformation. I am not an pessimist. I'm an optimist to the extent that, yes, we are giving the country to the younger people who are more competent, probably more intelligent, more passionate, and more adequate to adopt technology than us. So that is why the solution will come. It is coming. Probably only small solution is that we are having with NJSC. Again, judicial intransigence is also responsible, because the way they decided, so the mandate of the parliament, 70% of the assemblies have agreed upon the National Judicial Commission accountability bill, and yet the Supreme Court had the audacity to throw it out dustbin without compromise, without understanding it. We all know that there is no significant in constitution. There is no case of collegium. You have created collegium. You know it is a monster, like late Justice J.S. Verma said, because he created it. He was the one person who was given the judgment in what is called about the Advocate Association of Supreme Court vis-a-vis Union of India. He was the one person who said, who created the collegium. He was the person who said, I'm against it because it has not served the purpose. So was Justice Shekhar Patnaik, because he was a victim of the system, collegium system. Now, then Supreme Court of Dasi, without reforming them, they said, okay, only partially you can give the government to do it. And that is what led to delay. And now, of course, with the new thing changing place, we are getting appointments. But making appointments, it could solve the problems in India. We find there is one judge for probably 8 million people. Now, if we actually that will solve the problem, I think that's only cosmetic. The real transformation come if we actually develop human consciousness to make it a litigation free, ensure our executive and legislator work hard to provide justice. If we can provide justice at the village level, at the taluka level, at the district level, then I think these courts will not be clogged with so many cases. That's the basic understanding. So I think apart from learning law, we also learn the ability to undo the reality, to also develop a passionate for human being, raise our own consciousness as a liberal, open, dynamic human being. If that is possible, I think litigation cost will come down and court cases will come down, and we could still have what is the essential aim of law, a free, fair, liberal, democratic, justiciable social order that is in benefit of all of you. So thank you, Ritu, for giving me the time. to speak. If I have spoken more time, that's okay, because as a teacher, I always take 1 hour to my class. So I think I still restricted myself. So thank you. Yeah.
Thank you so much, sir. We also have with us additional district judge Yadav Ji with us. यादव जी, मेरा सवाल आपसे ये है, आप जुडिशरी के एक बहुत देर तक आप एक जिसे हम बोल सकते हैं एक संबंध रखा है अपने जुडिशरी से। इंडिया में कानून की कोई कमी नहीं है। इंडिया में अगर कानून ना भी हो, हमने बहुत बार देखा हुआ है, या तो उसको जुडिशियल एक्टिविज्म कह ले या जुडिशियल इनोवेशन कह ले, जुडिशरी ने हमेशा एक प्रोएक्टिव रोल प्ले किया हुआ है। बट अगर हम प्रैक्टिकल एस्पेक्ट की बात करें, आपके विचार से ऐसे कितने प्रैक्टिकल जुडिशियल रिफॉर्म्स हुए हैं जिससे कि सही में इंसाफ मिल सकता है, एक जस्टिस जिसे हम कहते हैं कॉमन मैन को, वो डिलीवर हो सकता है? यादव जी आप।
मैडम नमस्ते सभी को।
नमस्कार सर।
दरअसल क्या है, मैं कोर्ट में काम किया हुआ हूँ, तो मैं प्रैक्टिकल जो प्रॉब्लम्स आती हैं कोर्ट में वो आपके सामने रखूँगा। दरअसल क्या है कि अपना जो इंडियन जुडिशियल सिस्टम है वो पूरा जो है ब्रिटिश इंडिया की देन है। ब्रिटिश इंडिया के जाने के बाद एज इट इज इंडियन जो है इंडियन जुडिशरी को एडॉप्ट कर लिया गया। तो वो ही मतलब जुडिशियल सिस्टम जो है अभी तक हिंदुस्तान में चला आ रहा है। टाइम टू टाइम इसमें रिफॉर्म्स होते रहे हैं। और जैसे जूरी की एक व्यवस्था होती थी कि जजेस के सामने जो एविडेंस आती थी उसके बाद जूरी की राय लेके जज अपना फैसला देता था। लेकिन 1973 के CRPC आने के बाद वो सिस्टम खत्म हो गया। और पहले जो है सेशंस केसेस में कमिट होने से पहले केस में एविडेंस कलेक्ट की जाती थी। 1973 के बाद वो जो है कमिटल कोर्ट में जाने से पहले जो एविडेंस कलेक्ट की जाती थी वो सिस्टम खत्म हो गया। तो टाइम टू टाइम रिफॉर्म्स होते रहते हैं जुडिशरी में। मैं एक मतलब जो है बहुत अच्छा आपके सामने एक उदाहरण पेश करना चाहता हूँ। है तो दुर्भाग्यपूर्ण, लेकिन आपको ये चर्चा के लिए वो जो है बताना बड़ा ज़रूरी है। आपको मालूम होगा 15 साल पहले 10-12 साल पहले दिल्ली में एक निर्भया कांड हुआ था। उससे पूरा देश हिल गया। जुडिशरी सिस्टम पर आंखें उठने लगी और जुडिशरी पर जो है तरह तरह के आक्षेप होने लगे। तो वास्तव में ये पूरे सिस्टम के लिए बड़ा दुर्भाग्यपूर्ण था। तत्कालीन शासन ने एक ऑनरेबल जस्टिस JS वर्मा की अध्यक्षता में कमीशन का गठन किया। और कमीशन गठन होने के बाद राष्ट्रीय स्तर पर, अंतर्राष्ट्रीय स्तर पर विधिवेत्ताओं से, सामान्य नागरिकों से, लेमैन से, सभी से उस कमीशन ने अपनी अपनी राय मांगी। और आपको ताज्जुब होगा कि बहुत अध्ययन करने के बाद जस्टिस JS वर्मा ने करीब 1000 पेज से ज़्यादा अपना मतलब जो है रिपोर्ट शासन को पेश की। तो राष्ट्रीय स्तर पर, अंतर्राष्ट्रीय स्तर पर लेमैन के द्वारा, विधिवेत्ताओं के द्वारा, सभी के द्वारा अपनी अपनी जो राय और विचार प्रकट किए गए। तो उस कमीशन रिपोर्ट में वो सारा इन्वॉल्वमेंट था। और जस्टिस वर्मा ने सभी का निचोड़ उसमें जो अपनी रिपोर्ट में शासन को पेश किया था। अब आप देखिए कि रिफॉर्म्स की जहाँ तक बात आती है, जुडिशरी में क्या रिफॉर्म्स हो सकते हैं, जुडिशरी में कहाँ कमियां हैं, तो उस मतलब कमीशन रिपोर्ट में सारी बातें आई थी। लेकिन आपको ताज्जुब होगा कि इतनी बड़ी रिपोर्ट आने के बाद भी व्यवस्था में कहीं कोई बड़ा भारी बदलाव नहीं हो सका। एक पॉस्को एक्ट जरूर आया था, प्रिवेंशन ऑफ ऑफेंसेस अगेंस्ट चाइल्ड, वो जरूर अपने सामने आया। तो लेकिन उसके भी देखिए आप इतने उत्साहवर्धक मतलब परिणाम सामने नहीं आए हैं। अभी उसी तरह की घटनाएं अभी भी देखने को आती हैं, बड़ी दुर्भाग्यपूर्ण है। दिन में कभी ना कभी कहीं ना कहीं कुछ ना कुछ मतलब जो इस तरह की जो है रिपोर्ट अपने सामने आती ही रहती हैं। तो अब रिफॉर्म्स की जहाँ तक बात है, तो रिफॉर्म्स तो जो हो रहे हैं और रिफॉर्म्स जो जरूरी हैं वो किए जा रहे हैं। शासन जो कर सकता है वो करता है, लेकिन है क्या कि जहाँ पर जो बड़े रिफॉर्म्स की बात आती है तो फिर किसी ना किसी के हित टकराव होने लगते हैं, और लोकतांत्रिक प्रणाली में उतने ज्यादा मतलब जो है किसी को नजरअंदाज करके इतना अमेंडमेंट हो नहीं सकते। अब जैसे एविडेंस एक्ट की धारा 3 में दिया हुआ है कि वो स्टेटमेंट जो कोर्ट के सामने ओथ पर दिए जाएं, एक तो एविडेंस में वो है, दूसरी एविडेंस वो होती है जो डॉक्यूमेंट्री एविडेंस जिसे अपन मानते हैं। तो स्टेटमेंट ऑन ओथ और डॉक्यूमेंट्स, अब वो जो है, अब इसमें एक जो है डिजिटल सिस्टम में ये जो है ये मोबाइल और इस तरह की जो है ये भी एक तरह की एविडेंस में जो है माना गया है, और इसको जो है डॉक्यूमेंट्स की परिधि में रखा गया है। मेरा अपना सुझाव ये है कि अगर अपन जो है जो धारा 3 जो एविडेंस एक्ट की धारा 3 है उसमें एविडेंस में जो स्टेटमेंट ऑन ओथ है बिफोर कोर्ट, तो बिफोर कोर्ट की जगह उसमें अपन थोड़ा सा एडिशन ये कर दें कि कोर्ट आइदर कोर्ट और एनी जुडिशियल ऑफिसर और एनी कमीशन जो जुडिशरी के द्वारा या जज के द्वारा नियुक्त किया गया हो, वो उसके सामने लिया गया स्टेटमेंट भी एविडेंस में पढ़ा जाएगा। तो इससे क्या होगा कि जो इन्वेस्टिगेशन के टाइम में जो एविडेंस आती है, कलेक्शन करती है, पुलिस कलेक्शन करती है, तो वो किसी मजिस्ट्रेट के सामने उसको रिकॉर्ड करवा लिया जाए और वो चीफ की तरह उसका यूज हो। तो चीफ की तरह यूज होने के बाद जब जो कोर्ट में केस जाए तो एक्यूज के सामने अपॉर्चुनिटी रखी जाए कि भाई ये एविडेंस की चीफ है, अब इसको आप क्रॉस कर लीजिए, है ना। तो उसमें क्या है, होता क्या है कि 2 बार फिर जो चीफ करानी पड़ती है कोर्ट में। पहले क्या इन्वेस्टिगेशन के टाइम में पूरा एविडेंस के टाइम में पुलिस स्टेटमेंट्स रिकॉर्ड करने पड़ते हैं, पुलिस स्टेटमेंट्स रिकॉर्ड होने के बाद फिर एज इट इज कोर्ट में पेश किया जाता है। अब मैं बताऊं बात क्या है, ये क्यों जरूरी है। दरअसल क्या है, कोर्ट्स की जो वर्किंग है वो इस तरह की है कि कोर्ट के सामने किसी भी पक्ष को अपना पूरा मामला पेश करना पड़ता है। इनिशियली क्या है, आपका मामला क्या है, वो कोर्ट है, तो अब वो ये इसमें इन्फ्लिजमेंट हुआ है तो फिर सामने वाले को जो है उसके लिए नोटिस जाता है कि भाई सामने एक पक्ष का ये कहना है और आपका डिफेंस क्या है। तो पहले कोर्ट क्या करता है कि एक पक्ष की बात और उसका डिफेंस दोनों को अपॉर्चुनिटी देके पूरा एक रिकॉर्ड कलेक्ट कर लेता है। अब बात क्या होती है कि जब ये रिकॉर्ड सामने आ गया, इसके पीछे ऑब्जेक्ट क्या है, भाई कोर्ट ये सोचता है कि कभी कोई पक्ष कोई बात नहीं कहने लगे, कभी कोई डिफेंस कोई बात नहीं कहने लगे, तो एक मुद्दे पर जो है दोनों पक्ष को लाके उसको जो है तय कर लेते हैं। अब उस चीज को एविडेंस के रूप में प्रमाणित करना पड़ता है। तो बात क्या है कि जो 2 बार जो अपॉर्चुनिटी होती है, इसमें एविडेंस रिकॉर्डिंग में बहुत टाइम लगता है। मेरा अपना सुझाव यह है कि एविडेंस रिकॉर्डिंग के लिए कोर्ट कमीशन जो जारी कर दे, दोनों पक्षों के जो है बयान ले और बयान लेने के बाद उसका जो बंडल जो रिकॉर्ड बने वो जो है ट्रायल कोर्ट के सामने पेश कर दिया जाए। और ट्रायल कोर्ट में जो एविडेंस रिकॉर्ड करने में जो टाइम लगता है तो उसकी बचत हो सकती है इस तरह से। और क्रिमिनल केसेज में क्या है, जो मैंने अभी बताया कि किसी मजिस्ट्रेट के सामने या कमीशन के सामने बयान रिकॉर्ड किए जाए और वो चीफ की तरह उसका यूज हो। ये अभी हमारे पुराने एक पूर्व वक्ता ने कहा कि 3.5 करोड़ के करीब मामले हैं। ये बात सही है कि ये कोर्ट्स में बहुत पेंडेंसी है, कोर्ट में 3 करोड़ 3.5 करोड़ से ज़्यादा मामले पेंडिंग हैं। लेकिन एक तो बात क्या है कि समाज में जो पारदर्शिता आई है, जो जागरूकता आई है और जो प्रतिस्पर्धा आई है, इसके सबके रहते जो है ये मामलों की संख्या बढ़ी है। इन मामलों में क्या है, कुछ फास्ट लिटिगेशन भी। तो अब कोर्ट को ये तय करना होता है कि जो मतलब जो रियल लिटिगेशन है उस पर ध्यान दे। फास्ट लिटिगेशन, तो फास्ट लिटिगेशन को भी जो डिस्करेज करने के लिए कोर्ट कार्रवाई करता है, लेकिन कोर्ट के पास क्या है कि मिसलेनियस काम इतना रहता है कि वो इन फालतू चीज़ों के लिए दिमाग अपना लगाता ही नहीं। सोचते नहीं है। अब क्या है, होस्टाइल विटनेसेज की एक बात आती है। आजकल देखिए 80% केसेज में विटनेसेज होस्टाइल हो जाते हैं। अब होस्टाइल विटनेस के लिए जो है कोर्ट अगर चाहे तो उनके खिलाफ कार्रवाई कर सकता है, ओथ के ऊपर लिया हुआ बयान, और उसको जो है लेकिन होता क्या है कि कोर्ट अगर ये कार्रवाई करेगा तो पहले उसको जो है बयान रिकॉर्ड करके उसको नोटिस देगा, जिस जो विटनेस होस्टाइल हुआ है, और उसको नोटिस दे के फिर खुद ही कंप्लेंट उसकी जो है बनाए। कोर्ट खुद कंप्लेनेंट की तरह उसको कंप्लेंट तैयार करें और फिर कंसर्निंग जो है मजिस्ट्रेट के यहाँ भेजे या फिर सीजीएम के यहाँ भेजे। अब इतनी जो है माने मिसलेनियस वर्क जो है कौन जो है बड़ा है, तो कोर्ट ये होस्टाइल विटनेस को इग्नोर करके वो अपना काम आगे निकाल देता है। और ये अपना मतलब जो है कोर्ट के पास मिसलेनियस काम इतना रहता है कि वो अपना दिमाग कहीं चला ही नहीं पाता, इधर उधर तो लगा ही नहीं पाता। और कोर्ट के सामने ये होस्टाइल विटनेस के 50 तरह की बातें रहती हैं। तो ये पेंडेंसी की बात जो है सबसे ज्यादा इन तरीकों से जो है परेशानी है कोर्ट को। अब कुछ लिटिगेशन फास्ट लिटिगेशन होते हैं, फास्ट लिटिगेशन के लिए फिर जो है कोर्ट अगर कार्रवाई करे तो वही लंबी प्रक्रिया, उसको नोटिस दो, नोटिस देने के बाद फिर वो जो है इसमें और फिर उसमें उसको अपॉर्चुनिटी दो। है क्या, इन सब चीजों से बचने के लिए कोर्ट अक्सर ये सोचता है कि भाई बाईपास करो इन सब चीजों को, अपना मेन काम है। वो सब बातें जो है कोर्ट के लिए जो सबसे दिक्कतपूर्ण है। जहां तक रिफॉर्म्स की बात है, जस्टिस वर्मा कमीशन ने जो रिपोर्ट आई थी, आप देखिए कि उसमें सब राष्ट्रीय स्तर पर अंतर्राष्ट्रीय स्तर पर विद्वताओं के जो विचार हैं, उनकी राय है, लेकिन कुछ भी नहीं हो सका। कोई भी मतलब सब्सटेंशियल मतलब उसमें रिफॉर्म्स कोर्ट के सामने या कोर्ट वर्किंग के सामने नहीं किए जा सके, क्योंकि कहीं ना कहीं जो है प्रक्रिया आड़े आ रही थी। तो अल्टीमेटली वो माने जो 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 प्राचीन जो पुरातन जो चल रही थी, जो ट्रेडिशनल जो वर्किंग चल रही थी कोर्ट्स की, उसी तरह जो है कोर्ट्स को फिर काम करना पड़ रहा है। अब भी देख लीजिए कहीं मतलब जो है कोई गिरावट नहीं आई है किसी में, बराबर उसी तरह कॉन्स्टिट्यूशन चल रहा है। तो कोर्ट के सामने ये सबसे बड़ी समस्या रहती है।
Thank you, sir. If any participants have any question, they can raise their hand and we will unmute them and you can directly connect with our panel. In the meanwhile, Vikas sir, there's a question. You had basically discussed about how the pace at which the judicial reform is going, it's slow, but then we also need to appreciate the fact that there is a certain form of judicial reform going on, and it's very easy for any one of us to criticize it. But sir, in reality, one cannot ignore the fact also, the concept of e-court came back way back in 2014. And right now, the stat says that 40% of the fund is lying unused. So just wanted to know your opinion that if we had judicially used that fund right from 2014 till 2020, the way the courts were scrambling up during the pandemic because of lack of infrastructure, especially with regard to the e-court, we could have resolved this problem in a much better and judicious way. Vikas sir. Sir, you're unmute. You have to unmute.
Yes, what do you say is correct to some extent, though it's not thoroughly I accept. But at the same time, for example, what the Judge Ss Yadav Ji has said, for example, there is a quite difficult task in the notices to be served, and then whether that witness or the party has accepted that notice or not, and it takes much time. I think for that purpose only, what is suggested by the Commission as well as by the Supreme Court also, that there must be an e-serving notice, right? E-serving notice. So need not to be bothered all the time that whether it has been served or not. What I think is that to reduce in the timings of procedures, that what exactly court has to follow. Every provisions, mostly the CRPC and the IPC, where the e-governance has to be accepted, or e-functioning style would be accepted. That's why one of the examples that e-served e-notices, right? That has to be served, right? So the court need not to be, bothered about whether it has been served or not. More or less, what I feel is that, because based on my experience in the research, that even if it is on the official website of the district court, if the notices are pasted, right, that also would be considered as a, maybe considered as a notice has been served. That how we otherwise generally use in a newspaper, right? That in a newspaper. So if it is, we have to think alternatives to that time-consuming process, right? And we obviously, if we start thinking on today, going to be implement within a couple of years, I understand that. But obviously, that's why I said we are moving on a right way, on a right direction, right? But ultimately, the results yet to come. That's what I can say. Right? So that's why for example, CRPC 154 also, right? So whenever any statement before the police officers and by the concerned accused, obviously it has to be accepted before the magistrate. So now, if we utilize there also the e-mechanism, right? That is the e-governance, e-procedure, administration procedure. I think it would be very easy to all of us. For example, any accident takes place, for example, right, on a midway of the road, highways. Now, at that time, or any quarrel takes place, right? At that time, police officers reaches there. He will write everything. He will use the panchanama and everything, right? But ultimately, the matter should go to the court after a week or after 10 days. So that is a time-consuming process. Instead of it, if it has been, utilized this e-administration process, where I think we all stakeholders are trying very hard to reach that, how these times can be, this duration, in fact, can be reduced and can immediately, known about the case that has been filed to the investigating agency, as well as to the public prosecutor, defense lawyer, if the accused side, if anyone, free legal services committees also we come to know that this kind of cases. So that process has to be prompt, right, to inform everyone from the beginning, from the time of when such act has been committed, right, till the case has been registered to the honorable court. That includes the pre-mediation process, which is now compulsory. So instead of that, to go manually, that's what is going on right now. I think if it goes with the e-administration, the time duration would be reduced. Automatically, it would impact on the reduction of the cases and early disposal, basically, not reduction of the cases, but early disposal. I think that can be achieved, right? So artificial intelligence really play a very vital role if we really take seriously. Here, automatically voice connected FIR can be launched, for example. Right. So what you are speaking of on a mobile app by the investigating officer, that automatically would be reduced in writing, right? It would be in writing, and then it can be immediately informed to the concerned persons. Consent here, it means that to the public prosecutor as well as the legal services department, that such kind of incident has took place. First information report has been launched, right? And then what the next step would be automatically, if it is through administration, I think it would be really help to all of us. So that's what my thinking is. Thank you.
I would like to continue on this topic, but before that, there is a faculty of ours, Sally ma'am. She wants to ask a question to Mohanty sir. Go ahead, Sally ma'am.
Thank you, ma'am, for this opportunity. Am I audible?
Yes, ma'am, you're audible.
Okay. My question is, in the backdrop of unjustifiable legislative inertia and hesitation for the reforms in personal law, the activist approach of judiciary is a ray of hope for us. But then, will it infringe the doctrine of separation of power? This is my question, sir.
Mohanty sir, would you like to answer that? Sir, you would have to unmute.
Yes, the question Dodge opens up two interesting debates. One, when we think of the issue of personal laws, and secondly, look at dispensing with justice. Now, what is actually happening? The Supreme Court in many times, in many judgments, have said it is in the directive principle of state policy. So, Article 43. So let's accept it and create a uniform civil code. That's one as far as personal laws are concerned. Now, what is happening? We have a different political culture. We look at this that will a community will agree and will create. It's a question of minoritism, and therefore this. It's not that. It's actually we are now putting these two things in different perspectives. There are many cases. For example, I was teaching the case of Soviet Russia. There are Kyrgyzstan, Tajikistan, Georgia, Turkmenistan, many areas which were Lithuania, Latvia, which were part of this Soviet Russia, and many of the enteral in that called Central Asian republics, and were actually Muslims. And in 1917, when the Bolshevik Revolution happened, with one stroke, they discredited all the Sharia law and all these Kaji courts and introduced what is called then the secular courts. And there were, of course, like any reform you do, as Gandhi would say or anyone would say, first people will ignore it, then they will criticize it, then they will contest it, and then maybe accept it, and sometimes they will also like it too. So it is a process. And initially, when it is actually, if you are unable to create a consensus after 75 years, then I think there is somewhere lacking in political will, or in our collective consciousness, or in the minority cases. Now, it is not a judicial reform. If it comes through law, it is not going to take away anything. Like when we happen, there are so much problems that if 372 will take 370 will go away, the country will be born. When Sharia law, triple talaq will ban, the country will burn. Nothing happened. So therefore, there must be a strong political will, and also only thing is that we must create a confidence among our states that okay, we are doing it not because of vengeance, not because of denigrating somebody, but because we have genuinely concern about the welfare of people. And therefore, judiciary has to also opinion. Because it happens if people accept, judiciary has to accept it. So I think we are looking at judiciary as a ray of hope, primarily because we have lost our trust in the people who elect and the executive we have. And that's the irony of the things. In a democracy, judiciary is the last resort, not the first resort. And therefore, I think, because ultimately, whom we are electing, they are our part. We are electing them with a thumping majority. And if they are not concerned about our welfare, if they are not able to give us popular justice, then we should not look at court every time. It is not court. Court's trust, as Constitution as says, like Supreme Court, it would be interpretation. So why to go dispute resolution? We'll find dispute. Now, eventually, wherever there are people, there will be disputes. But we must find out local level of our consensus. And democracy works on a consensus. So that's the problem. I think it's we still look at judiciary because we think less corrupt. And if you look at judiciary and you look, it is also bisected with corruption. It's also bisected with henpecking order hierarchy. Look at it. We call the local court judges they are lower court. Why do you call them lawyer? Do we hire a lawyer means what? It's a hierarchy. And do you think a lower court additional district judge is not applying his mind? And only Supreme Court judge can apply in mind who was for 10 years working under the same High Court judge, same additional district judge. You make somebody High Court judge who was working 10 years as an advocate under the additional district judge who is about to retire. Now suddenly the additional district judge has to wake up and say, "My lordship, is it democracy?" It's not. And is it court finding its order? Do you know how many Supreme Court judges have the Aadhaar card? Many of them don't. Do you know that Supreme Court has said we will put our website that who is how many of them put up? How many former Chief Justice has come out open? In fact, one Chief Justice went on to say that the office of the Chief Justice doesn't come under the RTI, doesn't come under the thing. Why? Why such opaqueness? Why not transparency? If you are supporting, we call him Nyamurti. If you happen to be a Nyayamurti, where is the Nyayamurti in your side? And I think, a no sitting judge will say that. They don't like it. I can say, because I don't care what they say, because the academician have the freedom. But the only question is that if you want to do, we are doing it not because they are the best, but because we are even the worst. जैसे कहते हैं ना, चोर के अंदर डकैत होता है, डकैत के अंदर चोर है, इसलिए limitably they are better, but not that bad. They are actually absolutely fine. So is everybody. That's the problem, and that's what we think they are best, because others are the worst. If others are doing their duty, if all IAS officers should have done their duty, we don't need a single NGO to work for it, because they don't do it. They are now. Look at this. This is what is called now vaccination, where the district magistrate have been concerned, clear, carefully. That all vaccination are taken place. Where the DM is strong, that we want to do literacy, that's district have become literacy. Where the DM has wanted, we have to make it open defecation. No, what is called now free of open defecation. That district has become free of open defecation. But that is required both political and executive will. Unfortunately, we create a judicial system of bureaucrats who are first self-serving, secondly political serving, and that is why, and not public serving. And unfortunately, everybody calls themselves public servant. I don't want a servant. I don't want, and I don't call them a servant. I don't want it. They call public servant. But you have become calling yourself public servant and become yourself public master. That doesn't have to happen. You call yourself officer, fine. I'm happy calling you officer, but don't become servant and then kick me and saying that I'm a master once you haven't. That's the problem. If one that's solvent, so it's everything interlinked. If that happens, you are not going to ask this question. You would know that every people would look, whether a minority or majority, उसको fundamental है रोटी कपड़ा और मकान, वो मिल जाएगा, फिर वो खोजेगा दुकान, कहाँ पे? ना दारू का दुकान नहीं, वो खोजेगा where I get my ration need, और then education. You look, education is health. रोटी कपड़ा मकान मिल जाए, फिर education ढूंढेगा, health ढूंढेगा. He is not going to find out or is not concerned with the rest. But that's the fundamental to all. We have to raise that level of consciousness. Courts have tried to do that, including the local. They have litigation free legal aid. All they have tried to do it, but it's not court can do it. It has to come through people. It has to come to our popular mandate. We are creating government for that, to create governance. But where is the governance? And who are the people? That's why this is a very difficult question to answer, and I cannot answer this simply. But that's what actually happening. Thank you.
Thank you, sir. We have Nakul Singh Chauhan, professor, with us. उनको एक यादव जी से क्वेश्चन पूछना है. Go ahead, Nakul sir.
गुड मॉर्निंग सर.
गुड मॉर्निंग.
सर मेरा जो सवाल है, पहली बात तो एकदम एक लेमैन के रूप में पूछा जाएगा, क्योंकि मैं लॉ का प्रोफेशनल नहीं हूँ, मैं एक मैनेजमेंट प्रोफेसर हूँ, बट मैं लॉ में बहुत इंटरेस्टेड हूँ सर. तो इंदौर की जो हाई कोर्ट बेंच है, एक दिन मैं प्रोसीडिंग्स देखने गया था, एंड सर मैंने ये देखा कि मैक्सिमम केसेस में जो वकील हैं वो प्ली ऑफ एडजर्नमेंट लेके प्रोसीड करते हैं.
क्या
सर प्ली ऑफ एडजर्नमेंट,
हाँ,
कि अगली तारीख जो है वो मिल जाए उनको. अब सर कुछ केसेस में उनका प्ली ऑफ एडजर्नमेंट वैलिड होता है जब कोई ऐसा डॉक्यूमेंट होता है जो उनके पास मिसिंग होता है या पुलिस से उनको रिसीव नहीं हुआ होता है, बट बहुत सारे केसेस में प्ली ऑफ एडजर्नमेंट इसलिए दी जाती है क्योंकि वकील अंडर प्रिपेयर्ड है. अब सर एक हमारा जो मुद्दा है, आज जो टॉपिक है, वो ये है कि कैसे हम जुडिशरी का टाइम बचाए और कैसे ज्यादा से ज्यादा केसेस डिस्पोज ऑफ कर सकें जल्द से जल्द. बट आपको नहीं लगता कि ये प्ली ऑफ एडजर्नमेंट का जो सिस्टम है, इसकी वजह से डिले जो है वो और ज्यादा बढ़ता है?
बर्चले क्या है, आपके क्वेश्चन में ही आपका जवाब छुपा हुआ है. कोई भी एडवोकेट जब केस बुक करता है तो पूरा केस स्टडी करके ही बुक करता है, और बुक करने के बाद फिर वो जो है केस को जो है टाइम टू टाइम, जैसे पहले मोशन हियरिंग होता है, हाई कोर्ट्स में मोशन हियरिंग होता है. मोशन हियरिंग में एडमिशन जब हो जाता है केस का फाइनल हियरिंग के लिए, तो उसमें कोई एडवोकेट तैयार नहीं हो, प्रिपेयर नहीं है और प्ली ऑफ एडजर्नमेंट ले लेता है, जो आपने बताया. तो ये तो संभव ही नहीं है. कोई भी केस जो है बिल्कुल प्रिपेयर होके ही कोर्ट में दाखिल होता है और पूरा सब बिल्कुल तैयारी रहती है, लेकिन ओनली टू सेटिस्फाई हिज क्लाइंट. ये टाइम टू टाइम मतलब जो है प्ली ऑफ एडजर्नमेंट लेते रहते हैं. अब मेरे को आपके साथ ही 24 घंटे काम करना है, मैं 24 घंटे आपके साथ ही काम करना है, तो आपसे कितनी बुराई लूं? और एडवोकेट को जो है सामने जब जज के सामने आते हैं तो वो मतलब जो है अपनी बातों से, अपने व्यक्तित्व से कुछ ना कुछ प्रभावित तो करते ही है, ये बात तो सही है। 24 घंटे हम और आपको एक साथ काम करना है तो मैं आपका विरोध कितना लूंगा, ये बातें रहती हैं। तो प्ले ऑफ एडजमेंट 30% तो बिल्कुल फाल्स होते हैं। कोई कोई कारण नहीं है कि कोई एडवोकेट अपने मामले को प्रिपेयर करके कोर्ट में ना आया हो, बिल्कुल तैयार रहते हैं। लेकिन जैसा जैसा मतलब जो है अपने क्लाइंट को सेटिस्फाई करने के लिए और कुछ टू अर्न द मनी, ऐसा टाइम टू टाइम किल करने के लिए। अब आजकल क्या है, पहले मतलब कोर्ट का जो फंक्शन था वो, अब एडवोकेट की भी जो पॉलिसी थी वो ये थी इंसाफ लेना, इंसाफ प्राप्त करना। लेकिन अब क्या है कि केसेस लगते हैं और केसेस सिर्फ इस बात के लिए लगते हैं कि जैसे भी हो टाइम किल किया जाए और अपने पक्षकार को जब तक बच सके तब तक बचाए। तो ये अब हमारे यहाँ इंदौर में तो एक और परिपाटी थी, अभी भी है शायद, यहाँ पर 4,500-5,000 एडवोकेट्स हैं और 4,500-5,000 एडवोकेट्स में कहीं ना कहीं मतलब जो है ये निधन की या उनके फैमिली में जो है कुछ ना कुछ गमी की समाचार आते रहे। तो 12:30 बजे के बाद कोर्ट वर्किंग ही खत्म कर देते थे, वो करके कंडोलेंस करके और कोर्ट वर्किंग खत्म हो जाता था। तो एक चीफ जस्टिस हाई कोर्ट जज के यहाँ मध्य प्रदेश के थे, जस्टिस भट्ट, उन्होंने इस चीज का काफी विरोध किया। तो उस दरमियान कुछ जो उसमें सुधार हुआ, लेकिन सुधार कम हो पाता है फिर जैसे कि जैसे ही ढर्रे पर गाड़ी चलने लगती है। आप सही कह रहे हैं, प्ली ऑफ एडजमेंट का जो है कोई मतलब नहीं रहता। और प्ली ऑफ एडजमेंट के लिए भी जो है सीआरपीसी में, सीपीसी में व्यवस्था है कि रीजनेबल कारण पे ही जो है एडजमेंट किया जाए केस को। लेकिन होता क्या है, अब उसमें जो है ये तो जो है जस्टिफाई कोर्ट कह नहीं सकता कि नहीं साहब आपको तो करना ही पड़ेगा। तो प्ली ऑफ एडजमेंट की जो बातें आपने कही वो बिल्कुल सही है कि बिल्कुल आधारहीन मतलब जो है बेसलेस जो एडजमेंट होते रहते हैं कुछ तो, लेकिन कुछ रीजनेबल भी होते हैं। ऐसा नहीं है, कुछ रीजनेबल भी बातें रहती हैं जिसमें जो है कोर्ट्स में हियरिंग एडजर्न हो जाती है। लेकिन इसके बावजूद भी जो है हाई कोर्ट काफी जो है मतलब जो है नियंत्रण रखते हैं केसेस पर और काफी कुछ माने उनका जो है डिस्पोजल होता है। लेकिन बात क्या है, जिस तरह से जो है समाज में जागरूकता और जिस तरह से समाज में प्रतिस्पर्धा की बात आई है और जिस तरह से पारदर्शिता की बातें आने लगी, तो जो है इंस्टीट्यूशन ऑफ केसेस की वो जो है संख्या वो बहुत ज्यादा बढ़ गई। इसकी वजह से क्या है कि जो पेंडेंसी है वो ज्यादा मतलब जो है दिखती है और उनकी तुलना में जो है डिस्पोजल कम है। तो ये बात तो सही है। थैंक यू।
Thank you, sir. Thank you. Ma'am, I have another question. If you permit, I want to ask that question to Dr. Gandhi, sir.
Yes, sir. Please.
Good morning, sir. Sir, actually, when the lockdown was announced and it was being said that the courts will now hear all the cases, not physically, but on virtual platforms, I was a little skeptical. I thought that it might lead to a lot of problems. But an initiative taken by the Gujarat High Court, the Chief Justice of the High Court used to live stream his court and I used to watch the proceedings. Sir, I want to ask you, it's a twofold question. One, do you think in an online system, the cases are disposed of earlier as compared to a physical system, faster than a physical system? And two, sir, in the long run, can we have such a system where, you know, it is the choice of the pleader or the choice of the advocate to take the case on hearing on a physical platform or a virtual platform, if the virtual platform is effective? Because it will save up a lot of time and a lot of effort and money. People have to travel to courts sometimes from far off places, and they have to forego their income for those particular days. So this is my question to you, sir. Sir, you're on mute.
Okay, so with respect to your first question is how far this online hearing has been effective, either positively or negatively, whichever concern. I used to generally hear the online virtual arguments also in the state of Gujarat because it is live and you can see on the YouTube also. Now, and this is my habit since it has been started. In July, it has been started. So till now, every day, I generally concern cases in the subject area which I am interested. I generally find, because you may find across 26 benches are hearing. So in one or the other bench, you may find your interesting area, and then you can start listening on that. So that is one thing. Based on that experience, and then my own experience, with discussion with the other advocates who are my students also, and then who are my colleagues as well. What I felt is that it depends on how far it is effective. It depends on the gravity of your subject matter. And second is that it is on which stage that is at present. So for example, I give an example. If there is a witnesses to call upon, right? Because in some cases, High Court also calls to the witnesses for reaffirming and all these things. There are certain observation is that if it is virtual, then it would be difficult. Why? Because after asking every question to a witness or to a party, counsel prefer generally the gesture of the witness and the clients. Based on the gesture, he may ask the another question. So it's really very difficult practically that virtual, chief or cross or any questioning to the either to the victim or an accused or to the witnesses to be asked on. Now, at the same time, if it is written submissions, then obviously they prefer that there must be a submission, and then if any question from the judiciary or from the bench is required to ask, then it can ask virtually. So it depends. Your answer to your first question is it depends on which stage and the nature of the case and the gravity of the case that decides that how far it's going to be effective in nature. This is number one. So far as your second question is concerned, if alternative is or the choice is given once after this pandemic, then which would be preferable? Now, at the same time, if there is a final argument, obviously they prefer that it would be not virtual if it is final, and it would be physical. Because here in Gujarat, it experienced that immediately after that. I think 1 month back, it has been started physically also in the High Court of Gujarat and in every district. That was because of the major demand from the council, from the advocate side, right, from the bar, right, that now we can start physically also. Slowly we can go onto the track. It means that on some extent they are not much satisfied with the virtual court system. But definitely in future, what my feeling is that in future certainly there must be a two-way. Both the ways would be open. But again, practically it is very difficult if you are giving a choice. It would be difficult for the bench to handle the situation because some cases might be offline and some may be online. But obviously, if it is live telecast of that, obviously then it would be very easy. Saying that even if it is virtual or physical, it doesn't make much difference to the bench as well. So the nature of the case decides again at that point of time. I give an example why I'm thinking on that direction. Because in arbitration and in international commercial arbitration, basically, that also highly affected because of the COVID-19 situation. And now when the parties are from the overseas, obviously it would be very difficult for them to travel in this period. Obviously, what you said is rightly said that cost effective in nature. But even in arbitration, there is a provision in the overseas is that about emergency arbitration. Right. So in emergency arbitration means what? That within 6 months, the entire subject matter would be disposed of. And with the condition is that everything would be in the written submission, except if any chief or any cross-examination of any witnesses in arbitration requires, then the parties may have a choice. Now, they also tried that it would be virtual. Now, the condition and the problem is with the counsel in the arbitration is that they want the cameras in all the direction of the person who's either chief or cross examination is taking place. It's not only a one face camera, because they want to see the gestures. They want to see that no one others in the room of the witnesses where it has been taken chief or a cross-examination, right? So if that infrastructure is developed in such a way, then I think it might be easy in the judicial system as well that, the examination in chief and cross-examination may take place. But as I say that at present, our attempts are highly appreciated. I personally appreciate the attempts that we have made. And obviously, there are many things yet to be achieved in that direction. That is also true, right? So, in both the points, both the questions which you have asked, I think we can achieve if we start using effectively the e-mechanism, right? So, those days are, I think, not far away, where we can have in the court also the virtual, entire case would be finished up in the virtual, right? So what I'm thinking on.
Thank you so much
Very
for
well.
answering my question, sir.
Very well said, sir. We have one of our students, Kshitij. He wants to put a question across to Mohanty, sir. Kshitij, you can unmute and ask.
Thank you so much, ma'am, for the opportunity. Good morning, esteemed guests and everyone. My question is to Tapan, sir. The question is related to judicial reforms in respect of environment and public safety. So, since 1 to 2 years, there were several relaxations made for the environmental norms, and which made the exploitation of hydrocarbons for the several industries really easy. And 2 days ago, I have read that Wildlife Conservation Panel, after the opinion of Solicitor General of India, has also exempted oil and natural gas extraction from mining activities. So now oil exploration is a bit easy in the close proximity of protected area, and this has given harmful effects to the flora and fauna and the public at large. So I want to know is it a just or fair decision by the Wildlife Conservation Panel, and is there a judicial reform required in this aspect, sir?
Okay, thank you. Then we have to look at two different issues pertaining to the country. One is about environmental protection. Second is also about development. That is why when you grow up and study environmental law, you will be coming across a concept we call sustainable development. Now, of course, in the seminar, they have also put sustainability into it. Now, when you look at sustainable development over a period of time, because we cannot stop development or we cannot destroy environment, either way. Okay. So we have to only see how they both can meet. We can, for instance, as the population grows, we require more food, more mouths to feed. So where will we get about? As our lifestyles have changes, we required more hydrocarbons, we required more oil. No, how do you do? There are a technological solution to that. For example, like energy requirements. Some energy requirements we call non-renewable or renewable energy requirements. So we have wind, we have water, we have waves, we have sunlight, trying to do that. We have geothermal energy. We should do this. Secondly, as the population pressure increases, like wildlife issue, protecting that. Now, what you will do? If I take about in Madhya Pradesh, it's a tiger population country, tiger country. Now, if you kill a tiger, then you said, no, we tigers are a priority, environmental ministry comes. If a Adivasi is mauled by a tiger, you should know human rights is more important. Now, how do you look at both things? Because sometimes the conflicts are also become inevitable because of our lifestyle. Now, how many of us would go back to the previous lifestyle of naturopathic lifestyle that we would don't eat food, we don't use bicycle, we only bicycle? Some countries like Denmark, it's easy because it's a country like a state. It's a Denmark is a country with only 6 million population. So cycling around the buses is fine. But countries like us with so much diversity, so much issues, so it is difficult. So what judiciary have tried to do, in fact, at highest level of judiciary, they have also realized it that right to development is as important as right to environment. Both rights are indeed in constitutional rights. So what they call in constitutional law? We need to have a harmonious construction. And that harmonious construction has come through the idea of sustainable development. But we should not keep sustainable development just as a catchy and buzzword and then do whatever we want to do. Now we need to look at it both at the policy level, that whether that coal mine is important. You look at this Gandhi project, the best case you can find in Supreme Court. No, I, to the best of my knowledge, what they did, that POSCO case, that is not as what Justice not POSCO, but this other one is a POSCO case, where they wanted to establish Vedanta cell mines, and they wanted to get bauxite from the Gandhi mines of Koraput district. Now, if you use minings, then what will happen? The entire ecosystem will be destroyed. So what did they come out with? Now the case went to Supreme Court. Supreme Court said, okay, who is going to give land? The land will be taken from the tribals. Now if it's a tribal land, so who will accept? They said, okay, you are Gram Sabhas. There are 12 Gram Sabhas. And finally, only 2 Gram Sabhas agreed. But the rest of Gram Sabhas said, we are not willing to part with our land for a better lifestyle that you're offering. We're happy with our lifestyle, we're happy with our property, we're happy with our mountain, we're happy with our fountains, we're happy with our forest. And protect it. And that is why it is saved at the last moment. But there are many cases happening. We are now getting to know what is happening in Uttarakhand. All development, tourism. We have Kotakra, Salkananda, Bhagirathi. We only give them as a name, a religious name. But what is religion happening there? Tourism is not a religious one activity. Fine, pilgrimage is, but tourism isn't. So therefore, you have to balance it out. And how much court can do it? Court can only pass one order. And like, Kamalnath case, the very famous one, Kamalnath was a minister here. And interestingly, Kamalnath was a minister for the environment also. And then the case is Kamalnath versus Union of India. What they did, you wanted to change the track of the river because you wanted, like you were Mother Bhopal, there are so many lake view hotels. So they wanted to have a lake view, this thing. I know the river view hotel. And at what cost? Similarly, Ganesh Wood Corporation versus, in India, there Ganesh Wood Corporation because they wanted first case of environmental issues like that. Professor Rayappa, this case. So Raidu versus case. So all you find because there are sensitive people also, and courts have taken so much notices to try to force the executive to work in welfare of the people. Such one, of course, Ratlam, Bardichan versus Ratlam Municipality Corporation. No, these are issues where the courts have taken upon themselves the task to force the executive to work in protection of environment. But that's only to the extent they go. But also, the government also given a mandate for the development of people. How many of us, many of you said, sir, I want a fridge. I want a car. I want even fridge and car, maybe you can understand. But everybody said, sir, I want my deodorant, I want my cologne, I want my perfumes. You know how they are treated. They're all environmental hazards. But we don't want. And then probably, if you are putting some like fog, you are putting there, girls command, and it doesn't happen, but advertisement says so. And if that means we don't use deodorant, perfumes, people will run away from it. It's how you are creating consumerism. Until we stop consumerism, unless until we think about others. That is why the motto was, think global, act local. So if you do that, then I think we don't need judicial intervention. We have to force the government to do this. And that is why I always believe it is a community concept. It is a community conservation demands. And I think with FRA, Forest Rights Act, which is called Rights of the Scheduled Tribes and Others, Forest Dwellers Act 2006. With this act, we have created a system where at least theoretically, we have asked the land, the forest to the people, and they would maintain it. So if they maintain it, it becomes a success in both ways. They are human rights and their sustainability. Then I think through a legislature, through judicial intervention, we have been able to come a long path. But that has to be realized after 20 years. We'll see how it has done. But that's one method. And that is why I think judiciary has done wonderful work, because what is called entire course called environmental jurisprudence of Supreme Court. They might ask you questions in the courses, but importantly, they have done. But I think the judicial interventions is a limit to that extent. But unless nothing can work, unless people are conscious, unless community is conscious, the government is concerned, and we have to see to which extent we can use environment to our advantage. I am a little bit philosophical. I always say it was actually the Western philosophy. And most importantly, it was Descartes who said nature and culture are reversing. We have to mutilate nature to develop our culture of consumption. And that is why the nature-culture dichotomy took place. In the contrary, in our Indian jurisprudence or Hindu jurisprudence, we never looked at nature-culture dichotomy. We considered them together. But because of this scientificism, Western development model, Western-centric models, so this has happened this way. Otherwise, you look, every Hindu villager, every Hindu thinks worshipping the river as a mother, having a tulsi plant, having a bell plant, all this is why. And giving food to even cow. Do you know why we give Pitrapaksha and cow? No, that's crow, so not cow. Giving the cow as milk and Pitrapaksha as crow, because crow is the lowest from the animal. But yet, you do know, the only crow is only one bird in the entire universe who is responsible for the plantation of people and bird tree, because the nuts cannot become a tree unless until they passes through the digestive process of the cow, and it is you can only from cow's seeds drops has only protein. That is why you will find these plants where crow जहाँ बढ़ता है, ठीक है? इसलिए पीपल का पेड़ कभी इसे नहीं होता है, वो दरिया को उस बीच में कहाँ से हराना में छत के ऊपर वहाँ क्यों होता है? Wherever cow was put a drop, only then it will happen. That's the process. And thousands of years ago, our ancestors thought that crow had that capacity to environment, but we don't. Yes, so that's how things have to be done. No, I don't want to give a lecture on environmental jurisprudence, but that's how it needs to be understood. Okay, thank you.
Thank you, sir. We have one question from Yash Pathak.
Yes.
Yes, ma'am. Yes, ma'am. Ma'am, I want to ask a question from Yadav sir. Sir, section 122, that High Court rule making power of High Court. सर अगर ये पावर अगर किसी कमीशन को ट्रांसफर कर दी जाए तो क्या पीडी ट्रायल या फिर जो जस्टिस जो सर्व होती है क्या वो और जल्दी हो सकती है अगर ये पावर किसी कमीशन को ट्रांसफर कर दी जाए तो?
हाँ, दरअसल क्या है कि कमीशन जो है जाके किसी विटनेस का बयान ले सकता है, किसी मौके का मुआयना कर सकता है, तो वो आधा कोर्ट का काम जो है कमीशन करके कोर्ट के सामने रख दे तो बहुत जल्दी ट्रायल में जो है डिस्पोजल हो जाए। अब दरअसल है क्या कि ईच एंड एवरी वर्क जो है कोर्ट अगर करेगा तो उसमें जो है डिस्पोजल में टाइम लगता है। अब आप देखिए कि जो है अधिकतम जो है टाइम जो है कोर्ट का रिकॉर्डिंग ऑफ एविडेंस में ही खत्म हो जाता है, और फिर रिकॉर्डिंग ऑफ एविडेंस के बाद फिर उसको जो है मैच्योर करने में, केस को मैच्योर करने में, अब ये काम अगर जो है कमीशन में हो जाए, कमीशन अगर इस काम को कर ले तो उसको जो है डिस्पोजल के लिए ज़्यादा मतलब जो दिक्कत नहीं है। लेकिन क्या होता है कि ईच एंड एवरी वर्क रिकॉर्डिंग ऑफ एविडेंस, दरअसल है क्या, उसके पीछे लॉजिक तो ये है कि कोर्ट के सामने जब स्टेटमेंट विटनेस का होता है तो विटनेस का गेस्चर, विटनेस क्या किस तरह से बोलता है, कहाँ उसका झूठ, तो ये कोर्ट को मतलब जो है एसेस करने की बात है। लेकिन अब क्या है कि जब जो है कोर्ट में केसेस की जो है संख्या इतनी ज़्यादा हो गई तो ये कमीशन को या अन्यथा इसको काम को जो डिस्ट्रीब्यूट करना ही पड़ेगा। आगे पीछे ये निश्चित रूप से अपन को अमेंडमेंट करना पड़ेगा सीआरपीसी में, सीपीसी में, कमीशन के द्वारा जो है बयान रिकॉर्ड किए जाए और कोर्ट के सामने सबमिट कर दिए जाए तो कोर्ट अपना काम जो है फैक्चुअली और जल्दी से कर सके। अब हो क्या रहा है कि मान लीजिए रिकॉर्डिंग ऑफ एविडेंस करके तो रिकॉर्डिंग ऑफ एविडेंस में टाइम लग जाता है, 7 विटनेस के बयान होने हैं तो 7 विटनेस के बयान, विटनेस आ नहीं रहा, विटनेस पे एक्चुअल सर्व नहीं हो पा रहा। अब है क्या, ई नोटिस के लिए ठीक है, लेकिन कभी कभी क्या रहता है कि जो एक्चुअल जब नोटिस नहीं हो पाता पार्टी को तो एडवोकेट उस चीज़ को लेके कोर्ट के सामने आता है। अब कोर्ट ये मतलब जो जब एक्चुअल नोटिस नहीं हुआ है विटनेस को तो अपने यहाँ तो आधे जो पक्षकार है वो तो अशिक्षित है ना, तो कोर्ट ये मतलब कोर्ट के सामने एडवोकेट ये प्ली लेता है कि भाई अक्षम जो अशिक्षित पक्षकार है इसको ई नोटिस की नोटिस नहीं हो पाई, एक्चुअल नोटिस जब उसको होगा और एक्चुअल नोटिस अगर उसको नहीं हुआ है तो फिर उसको जो है कोर्ट मतलब फिर से अपॉर्चुनिटी दे देगा। तो इस तरह से जो है कोर्ट्स में जो है एक्चुअल नोटिस, एक्चुअल ये सब बातें होने से जो है क्या डिस्पोजल में थोड़ा सा डिफिकल्टी आती, थोड़ा टाइम लगता है। और फिर विटनेसेस जो है, गांव के विटनेस तो एक बार को आ भी जाए, लेकिन जो सर्विस में विटनेस हैं, डॉक्टर हैं, इन्वेस्टिगेटिंग ऑफिसर हैं, इनको आने में काफ़ी टाइम लगता है। अब इनके लिए क्या है कि कमीशन अगर जारी हो जाए, कमीशन जो जाके उनका बयान ले सके, इस तरह की जो है सीआरपीसी में, सीपीसी में व्यवस्था में थोड़ा अमेंडमेंट हो जाए तो थोड़ा डिस्पोजल में जल्दी हो जाए। ये प्रॉब्लम है। कमीशन, कोर्ट कमीशन अगर जारी किया है, चाहे ट्रायल कोर्ट ने किया है, मजिस्ट्रेट ने किया है, एडीजे ने किया है, हाई कोर्ट ने किया है, तो कमीशन को वही राइट्स रहते हैं जो उस कोर्ट को है। कमीशन को, कोर्ट कमिश्नर को वही राइट रहते हैं जो जिस कोर्ट ने जो कमीशन जारी किया है, तो उस कोर्ट को जो राइट है वही कमीशन को रहते हैं। तो वो फिर मतलब बहुत इजी हो जाता है। बट थैंक यू।
Thank you, sir.
Thank you, sir.
I'm aware of the fact that I had assured Gandhi, sir, that we would be winding up the session by 12 o'clock. So we'll just need 5-10 minutes more because there are some questions coming. Deepa ma'am, would you like to ask any question?
हाँ, थैंक यू रितु मैम। मेरा प्रश्न यादव सर से है। सर, जैसे कि आप न्यायाधीश रहे हैं एंड हम सब जानते हैं कि हमारे इंडिया में जो जुडिशियल हायरार्की है, इट्स लाइक सुप्रीम कोर्ट, हाई कोर्ट एंड डिस्ट्रिक्ट कोर्ट। बट क्या आपको नहीं लगता कि पेंडेंसी ऑफ केसेस को देखते हुए हमें इसे फर्दर एक्सटेंड करना चाहिए एंड वी शुड इंट्रोड्यूस द कॉन्सेप्ट ऑफ सिटी कोर्ट्स आल्सो? हर शहर में एक अदालत होनी चाहिए, जैसे हर शहर में एक गवर्नमेंट हॉस्पिटल होता है, तो ऐसे एक कोर्ट क्यों नहीं हो सकता?
नहीं, कोर्ट तो मैडम है, कोर्ट्स तो है, लेकिन बात क्या है कि जब तक जो फास्ट लिटिगेशन और जो उसको कम नहीं किया जाएगा, तब तक जो है ये इस पर जो कंट्रोल करना बड़ा मुश्किल है। अब होता क्या है, आप सिटी कोर्ट की एक की बात कहती है, आप मेरे ख्याल से मोबाइल कोर्ट की बात कर रही हैं, मोबाइल मूविंग कोर्ट।
नहीं सर, मैं मूविंग कोर्ट्स नहीं, हर शहर में एक अदालत अगर हो, जैसे अभी डिस्ट्रिक्ट लेवल पर होती है, ठीक है, या फिर एट द मोस्ट वी हैव कि मतलब ग्राम लेवल पर कुछ कमीशंस में आपको कोर्ट्स का कॉन्सेप्ट दिखेगा, बट व्हाई नॉट इन एवरी सिटी? उससे आई थिंक सो डिस्ट्रिक्ट कोर्ट के ऊपर बर्डन ऑफ केसेस का लोड कम होगा।
थोड़ा सा मैडम थोड़ा कंफ्यूजन है। डिस्ट्रिक्ट कोर्ट्स में एक कोर्ट नहीं रहता, डिस्ट्रिक्ट कोर्ट में कम से कम 15-20 कोर्ट रहते हैं। मजिस्ट्रेट फर्स्ट क्लास के कोर्ट्स रहते हैं, फिर एडीजे के कोर्ट्स रहते हैं, और डीजे एक कोर्ट रहता है। तो डीजे जुडिशरी सब, देखिए एक सुप्रीम कोर्ट का एक कंसेप्ट है, फिर एवरी प्रोविंस में हाई कोर्ट रहता है, हाई कोर्ट की बेंच भी रहती है, 3-4 बेंच रहते हैं, जैसे मध्य प्रदेश में 3 बेंच है, इंदौर और ग्वालियर 3 बेंच है। डिस्ट्रिक्ट कोर्ट, तो डिस्ट्रिक्ट कोर्ट इंदौर में कम से कम डिस्ट्रिक्ट जज का कोर्ट है, एडीजे के 15 कोर्ट है, सीजीएम का कोर्ट है, एसीजीएम का कोर्ट है, 15-16 मजिस्ट्रेट फर्स्ट क्लास के कोर्ट है। तो कोर्ट्स तो है, और हर एक कोर्ट के लिए मतलब जुरिडिक्शन बटा हुआ है। 4 थानों को एक मजिस्ट्रेट के यहाँ जो है जुरिडिक्शन है, 15 कोर्ट्स के 15 थानों का एक दूसरे मजिस्ट्रेट को जुरिडिक्शन है। तो कोर्ट्स की संख्या कम नहीं है, कोर्ट्स तो हैं, पर कुछ तो कोर्ट्स में प्रिसाइडिंग ऑफिसर्स जो है पोस्टिंग नहीं है, तो वो एक कमी है। कोर्ट्स तो है बाकायदा, लेकिन जो लिटिगेशन है वो बढ़ रहे हैं। समाज में जो जागरूकता जो पैदा हुई है, जो पारदर्शिता की बातें आने लगी हैं, और जिस तरह से प्रतिस्पर्धा बढ़ी है, तो उस तरह से ये जो कोर्ट्स में मतलब जो केसेस की संख्या बढ़ी है। अब बात यह है कि कोर्ट्स में या तो कोर्ट्स और उसकी तुलना में जितने केस बढ़े, या तो उनके कंपैरिजन में जो कोर्ट्स की संख्या बढ़ाई जाए। 5-7 कोर्ट रहते हैं, छोटी सी डिस्ट्रिक्ट में भी डिस्ट्रिक्ट जज के साथ मतलब जो है 7-8 कोर्ट और होते हैं। मजिस्ट्रेट फर्स्ट क्लास का कोर्ट रहता है, सीजीएम का कोर्ट रहता है, हर एक के अपने अपने जुरिडिक्शन है।
सर, ये कॉन्सेप्ट एक्चुअली म्युनिसिपल कोर्ट्स एंड टाउन कोर्ट्स से मतलब जो है आता है, जहाँ पे और छोटी जगहों पर भी जो है कोर्ट की व्यवस्था की जा सकती है।
आपका प्रश्न बिल्कुल सही है। अभी मध्य प्रदेश में ये व्यवस्था थी 5-7 साल पहले, 10 साल पहले मूविंग कोर्ट्स की व्यवस्था थी, गांव न्यायालय, ग्राम न्यायालय, तो उसमें क्या है, प्रेसाइडिंग ऑफिसर और उसका स्टाफ जाता था, छोटे छोटे केसेस का मतलब डिस्पोजल होता था, जैसे 10-5 हज़ार रुपए की लेनदारी है, उस तरह की वसूली के लिए इस तरह के कोर्स रहते थे, और छोटी मोटी चोरी और इस तरह के केसेस, मारपीट के छोटे मोटे मूविंग कोर्ट थी। लेकिन उसमें क्या है कि जब जो कोर्ट्स की जो तारीख होती थी उसमें माने आरोपी भाग जाता था, गांव से ही भाग जाता था। तो दिक्कत ये आने लगी कि जिस तारीख को जो कोर्ट्स गांव में पहुंचे उस तारीख को पक्षकार ही नहीं गांव, पूरे स्टाफ को लेके मूविंग कोर्ट कंसर्निंग गांव में जाए, और कंसर्न गांव में जाके वहां पता लगा कि आरोपी तो एक दिन के लिए भाग गया। अब आरोपी एक दिन के लिए भाग गया, मूविंग कोर्ट्स का वो जो कंसेप्ट भी फेल हो गया। 5-7 साल पहले था, मध्य प्रदेश हाईकोर्ट ने ये व्यवस्था की थी कि हर गांव के लिए मूविंग कोर्ट्स भेजे जाए, और जो है जाके मौके पर जो है फैसले हों, छोटी मोटी मारपीट के केस, छोटी मोटी चोरी के केस, छोटे मोटे लेन देन के केसेस का डिस्पोजल मौके पर जाकर ही किया जाए। और मजिस्ट्रेट इसके लिए नियुक्त किए गए थे, ग्रामीण न्यायालय नियुक्त किए गए थे। ये गाड़ी होती थी, ये महिंद्रा की गाड़ी, उसमें जो कोर्ट और उसका स्टाफ जाता था गाँव में, लेकिन उसका इतना इफेक्टिव वो ही नहीं निकला, उसका परिणाम नहीं आया। तो धीरे धीरे या तो डिस्ट्रिक्ट माने जो है मुख्यालय पर कोर्ट्स हैं, हर डिस्ट्रिक्ट में 10-5 कोर्ट्स की व्यवस्था रहती है। Thank you.
Thank you, sir. Before we move on, there's one student who wants to ask a question. Before that, there's one question of mine to Dr. Gandhi, sir. This is actually a question to Vikas sir and Mohanty sir. Being a faculty of National Law University, just a personal opinion of yours, do you really think so that if you're talking about judicial reforms or legal reform as such, the process can be accelerated if we have an all India judicial service, considering National Law University do produce some of the best legal mind in India? So do you really think so Indian judicial, all India judicial service can be an answer to this problem? Vikas sir, first to you.
Thank you, madam. I think the government is working upon All India Judicial Services examination. So far as this is number one. Number two is so far as the National Law University students' contribution to the litigation being joined as a bar or a bench. I think the students now, the ratio is now increased. Students are participating and then clearing the exams. They're sitting as a judicial magistrate first class, or some of the students also joined as a public prosecutor, right, in the different, their own domicile state. In spite of, I would say that last year, since in JNLU, Gujarat National Law University, now students are appearing for the judicial exams of multiple states. Let's say it belongs to Delhi, for example, and then Delhi Judicial Services, they apply at the same time Rajasthan, at the same time Gujarat as well. Because at present, the high courts are taking exams in most of the states for the judicial magistrate first class. So they are appearing for those exams. Apart from that, there are many, I think the alumni who have joined the public as a public prosecutors as well. So I think contribution has been started. Earlier, the time was when we were discussing when I joined the National Law University in 2006, 5 and 6. At that point of time, there was a debate in such conferences was that there's no contribution of the students from NLUs because they generally joins the law firms where you may find a very handsome box and everything. So they don't have much contribution into the real litigation and in the judiciary, either in the bar or a bench. But now I think slowly in that aspect also the scenario is changing, right? They are also, started having an, joined the judiciary at the same time as a council, litigating council also. Even students, what what I feel is that students who are joining law firms, they also much interested to join litigation team in the law firm, rather than to go simply drafting and conveyancing, right? So I think that problem would be solved, as the time goes, and contribution from the law students, NLU law students also will be, remarkable in near future.
Thank you, sir. Mohanty sir, my question plus there is this last question from the students that we would be taking before we end the session. That would be from Garima Shukla. Garima, you can ask the question and then I would request Mohanty sir to answer both the questions. Garima, go ahead.
Thank you, ma'am. Good afternoon to the respected panel. My question is from Tapan sir. Sir, nowadays government yields too much discretionary over capricious influence and uses its arbitrary against the economic weaker section of economy. So then how can we achieve a sustainable system? Because when there is so much of corruption still exists.
Yeah, thank you, Garima. That's a very nice question to say that. But yes, I will take their question first and second question later, because that is already answered. So I just add on to that. But your question is important in the sense, yes, when you say a government has been much moved by the idealism and the money of the capitalist. Now, which government in India from 1947 onwards has not been influenced by capitalists? BJP government of 2014 did not create Mukesh Ambani. It didn't create Adani either. It didn't create Tatas. It didn't create Birlas. And yes, what happened, unlike to other agents, and look at the, and we have also tend to think mostly by a communist or Marxist ideology. Don't you think companies like, Nirma washing powder, now we don't use it much. Like, what is sometimes we think like Hindustan Unilever. We think there is Hindustan, it is India. It is not Indian company. Coca-Cola is not Indian company. Right? If we are not governed by our company, we will be governed by the foreign companies. So tell me how many people are drinking Coca-Cola now? Coca-Cola is Indian company. And is it an essential idea? For example, at least Tata Steel produce steel for India. But what does Coca-Cola does for us? In fact, I tell it is recolonized. I call it is called Coca-colonization. Some people call like eating McDonald's. I call it is McDonaldization. So how to what you are getting McDonald's? It is not created by Modi government or somebody else. So eventually we have to think, yes, corporates are important. That is why I do not disagree when law school students join corporates. I said, yes, corporates are as important for growth of development of the country as they are. And even in fact, think Gandhi. During the Gandhi's time, who was his friends? Damsadi Tata. Who were his friends? Jamalal Bajaj. Isn't it? So it is not to be wrong. We put it that yes, because all companies all over the world, including Microsoft, have become exploitative in nature. Because in 1995, it was this Nobel laureate economist Milton Friedman who says corporates have no social responsibility except making profit. So that is a bottom line also. What they do is side business, or for us, little bit loaves here and there. So is it? So every government will ultimately, your actually votes are interestingly in India as not determined by the money. Otherwise, Mukesh Ambani would have been Prime Minister of India. So it's not always also money. It's also about our votes will cast, people will cast. And we are given, Indian people have actually shown tremendous capacity to choose government. I give example of 2000, this 14 in 18 in Odisha, where they choose a local government for the state. There was simultaneous election, but they keep Modi government a mandate for the central election. So there are even a state which is as poor and as illiterate are sector do so. So people have capacity to distinguish that. And I think, yes, that is why the pressure groups are important. That is why civil society is important to bring government into track. We should not get a despotic government. So if Modi government is wrong, we must contest it. We must question it. And we must create pressures on them. Something they have done. And they are the economic failure too also. Take Article 370 is fine, but we are also economic failure. Look at the petrol prices rising. And also security question. So this is also to be questioned. That's what important. And that is why education is important. And that is why legal education is important. And that should make And I think as you get the government as you are. The captain is as good as the team. So if you have got the government, you are also responsible for that. Right. So we need to look at that way. And all young guys now you will voting. So you should decide who to vote, how to change. That's one. Second, and if you want to have a Vijay Bhargava, Kailash Vijay Bhargava, it is your choice. I didn't vote for him, so I don't want to. It depends upon what type of government you want. Right. Secondly, it's also important to think as she was asking law schools. I think the idea of National Judicial Service has come. And it has to be implemented, if not now, but sooner. Because, like, of course, I don't see we have IS officers and we know what they are. So I also believe that if we have NJSC, but only thing what will happen, at least it will open the ambit, it will bring more people into it. And I also believe, don't tell law school student join bar and bench. When you say that, what do you mean? You only mean graduation. We have a post-graduation also. And 90% of my postgraduate students join bar, bench, or academics. So you cannot discount that law school students. And if you think law schools only constitute of undergraduate law schools, then you are wrong. So we have also postgraduate who are PG students. So why don't you count them up? And many of them are into other professions, especially in bar, bench, and thing. So they are changing it. But I also think even if you have a collegium system, let the application for judgeship come to the UPSC. Let it become transparent. Everybody should know who is applying, what are their qualifications, what are the contribution, what are their actual wealth, and what are their hidden wealth. And then only if you do collegium, I don't mind. But don't tell government of India will look at it. I know what government of India does also when the party in power are not in power. I have cases when you make what is called your advocate general to judge. Now this in same court. Now if you are doing the government now and the same high court, I don't expect that it is neutral. There is the problem. He may be neutral, brilliant. Individuals are there, but these are difficulties in things. I think I wholeheartedly support the idea of National Judicial Services, and that's what my take is. And I think I have answered both questions. Since I had tend to give a lengthy answers, so I would stop it here because times are also important.
No.
Thank you, Ritu, and thank you.
Thank you, sir. Thank you so much. Before we actually end this session, there is one last question that we are entertaining, that is on a request of our student to Dr. Gandhi, sir. Kiran, please ask the question. This is the last question.
Yes, ma'am. Thank you. Good afternoon, everyone. Myself, Kiran Vaishnav. So my question is to you, that why has the plea bargaining failed to achieve its desired goals of reducing backlog in the prison population, and also the digitization of courts are not meaningfully informed by the legal reform?
Okay, thank you. Nice question. Now there are two things. Plea bargaining hardly touches or influencing to the reduction of the cases, because the main concept of the plea bargaining is that if the accused has already been accepted that the act has committed, then there would not be required more trial on it, right? So, and for that the concession would be given so far as the punishment is concerned. So if it is taking in practice very seriously, obviously it was going to be effective. So reduction in the adjudication, that would be influenced because of the plea bargaining. It doesn't influence to the reduction of the cases or early disposal of the cases. Early disposal in one extent, that where it has been accepted, obviously no trial is required, and that is also limited act. It's not all the provisions that you can see in the IPC. The plea bargaining is possible, but it's there, and we have adopted it. This idea for considering that duration in the beginning, at the time of charging the after the charge sheet has been filed and produced it before the honorable court. Right, this plea bargaining will work. Right, this is one. And it's not much effective, that is true, unless it has been practiced very seriously. And practiced seriously is because it's not a fault of anyone, but unless what the benefit that the lawyers and the accused expect from and the judges expect from, unless that has been clear, obviously the counsel generally won't take the initiative to have a plea bargaining on that, because he wants to save his client. So that mindset is still there, right? So this is this is the first question's answer, and I think the second question also you have asked me that. What was it? Can you pardon please?
Yes, sir. The digitization of courts, sir.
So what's your question is digitization of what? No, it's
Kiran, you would have to unmute yourself.
yeah.
Yes, yes. Sorry. My question was the attempts of digitization of courts are not meaningfully being informed
No,
by the legal.
okay. Have you ever experienced that? For example, e-filing, right? So you get SMS also, right? That you have e-filed it, your number is this, right? So slowly it would be required to improve it on that, but and it has not been reached to the district level, district court level, unless you practice in the High Court or in the Supreme Court, right? You won't experience this, right? Because it's as work is going on. The Supreme Court has initiated in 2014, it started implementing, and now it's the second stage. Now it's a third stage, in fact, right? And in third stage, I think we are going to finish up. So first it would be Supreme Court and the High Court, and then when it has been succeed, if experience of successful on that digitalization, then obviously it will go to the district level as well, right? So we keep receiving SMS and all. So you do one thing, if any counsel who is practicing in the High Court in the Madhya Pradesh, right? I think you can join that particular firm, right, or a lawyer, where exactly you get an experience that once you registered it, how the SMS work upon, right? So I think it has been started, but not in every district level and every district of the state, right? Slowly we should improve. I think it's very good initiative taken by the court and the government. That's what my feeling is.
Thank you, sir.
Thank you, sir. And with this, we conclude our law conclave on judicial reforms in India, key to sustainability and inclusive growth. I would request Professor Swati Rai, International Conference convener, to kindly address a vote of thanks to all our guests.
Thank you, Ritu ma'am. Am I audible?
Yes.
Okay. Namaskar. A very warm good afternoon to our honorable guests, faculty colleagues, and my dear students. All, I, Swati Rai, Assistant Professor, Department of Law, Prestige Institute of Management and Research, Indore. I am honored and pleased to propose this vote of thanks for this law conclave on day 2 of the 16th PIMR International Conference. Feeling thankfulness and not expressing it is like wrapping a present and not giving it. Today, on behalf of the Department of Law and the entire Prestige Institute of Management and Research, Indore, I take the opportunity to put all our gratitude into words. Today's law conclave was indeed an intellectually enriching session. We were fortunate enough to have brainstormed the various aspects of such a significant issue of judicial reforms in the context of law, justice, and the judicial system. I extend my sincere and heartfelt gratitude to the guests and speakers of this session, Honorable Retired Justice Shri Ss Yadav Ji, Additional District Judge in Retired Additional District Judge Indore, Dr. Tapan Mohanty, Professor, National Law Institute, University Bhopal, and Dr. Vikas Gandhi, Associate Professor, Gujarat National Law University, Gandhinagar, for gracing this occasion with their esteemed presence, despite their busy schedule, and enlightening this gathering with their opinions on law and justice and reforms in judicial system of our country. I am very much confident that this session had many valuable takeaways for our dear students. मैं एक बार पुनः आभार व्यक्त करती हूँ हमारे माननीय अतिथियों का। मैं उनके प्रति अपनी जिन्होंने इतने प्रभावी रूप से अपने विचार व्यक्त किए, हमारे प्रश्नों के जवाब तो दिए ही और साथ ही हमें सोचने, विचार करने के लिए कई सवाल भी दिए। Once again, I thank one and all for making this law conclave a success. Thank you.
Thank you, ma'am. We are ending the meeting. We are ending this session.
Thank you.